Thank you all. Welcome to the Counterculture series of open source. This will be fun. I realize I am the only thing standing between you and lunch, so I will try to make this informative and useful to you. My goal is not to cover the breadth of open source, but to give you enough information to make you dangerous and to think about some things as you move forward with creating your own creative works and putting them out into the universe. So with that, got to do the legal disclaimer. This is educational. I'm not giving advice to all of you. Seek appropriate input from your legal advisors if you want to go explore this topic a little bit more. Two other disclaimers. I'm dealing with allergies. If my voice just disappears, I apologize. Just please bear with me. Last disclaimer, if you looked at my bio at some point, you might find an article about open source that may suggest that you should never use it or really be careful about using it. Very copyright establishment, pro-establishment of being careful with open source. That was written many years ago. I have come around to the idea that open source can live peaceably with proprietary types of rights. So I'm not a hater. I've come around. So the topics that I wanted to take some time with this morning is to really discuss the vocabulary of open source. I'm going to throw a lot of terminology at you. In fact, there is some up there, the copyright versus copyleft versus copy-free. And bear with me, some of it, we're talking about degrees of difference in some cases, but it's important to set that baseline understanding of what we're actually talking about. Open source, Creative Commons. So we'll spend a little bit of time of just kind of orienting ourselves around what the terminology is. I'll give you a basic framework for understanding the use of these different devices, these different techniques, both from a legal perspective, also with the business perspective in mind. A lot of my clients who are interested in using open source, it's usually for a commercial, for-profit type of business. So I am familiar with both the legal aspects and how it folds in and dovetails with the business interests. And finally, implementing the license. Open source licenses, copyleft, copy-free, whatever you want to call them, whichever form of license you choose, they've largely been written. So there's not, this last section of the presentation, I think, for IP practitioners tends to be the boring part because we don't get to get in there and really dive through and tweak language. The licenses are what they are, but we'll talk about them. I'll show you some examples of the language so that you see kind of how it all works at the end of the day. So you've probably heard maybe 3 or 4 times now what the definition of a copyright is, so I'm not going to belabor the point. I've kept a very simple definition here. It's a right granted to an author to exclude others from doing a number of activities. Some people have longer lists, some people have shorter lists, but that's kind of the basic: reproduction, adaptation, distribution, performance, and display. It's really important to understand that copyright, for purposes of our discussion, exists at the time of creation. Because everything else, this whole open source movement, is based off of dealing with that fact, that initial right that's created upon creation of the work, or fixing the work in a tangible medium, all the rest. Some people have, Alex did a great job of going through what a copyright is and talking about originality and having a modicum of creativity. Originality in the copyright world is very low threshold. It has to originate from me as the author. This slide, this set of slides, this is copyrightable expression because although I used lots of sources to kind of pull information together, I made some decisions about what to put on the slides, what to leave off, how to express the points that I'm trying to make. So I didn't take this from anybody else. I created it. It's boring as it looks. It's all me. And you know, it meets that level of originality and modicum of creativity. So a lot of the work that you create is going to have some element of copyright protection to it, most likely. So if we use that as our basic framework of, I've created something and so there may be some copyright protection or elements that were created at the time of when I made that work, then we can think about, well, how do we release this work into the public through an open source paradigm? So the movement that has evolved, you most commonly hear to it as open source. Another term you might hear is copyleft, and that is not, you know, an incorrect symbol of the traditional copyright sign. This is actually the left-facing C, copyleft. That's cute, right? That you use when you are putting a work into, you know, in open system, we'll say. So what we're doing here is basically you have a copyright, and copyleft is a licensing arrangement that allows you as the author to give certain rights to future users. The right to modify the work, the right to redistribute the work, create derivative works, etc. And like I said, in probably every industry in it, you know, the vernacular between open source and copyleft is used interchangeably. Only the lawyers, you know, have a good time trying to tell you that they're different things. There's this other type of open system that I will refer to as copy-free. This is even a more broadly termed form of copyright license that allows people, users, other creators to take your underlying work and pretty much do anything with it. You are basically telling them, I will not impose any sort of restrictions on your right to use. It is different from, and anyone in the Copyright 101 session heard a lot about public domain and what it is, and the tensions that the current copyright laws create with public domain. It is different from public domain. Public domain is, it's not a place, but it is an absence of other protectable rights. So copy-free, I am putting a license into the world with almost no restrictions. Public domain means I don't have any right to say anything about what happens to that work. Why do we make that distinction? And this is where you know, there was some good discussion about this in the other session. Copyright exists upon creation. I've said that several times. You've heard it several times. There is no recognized way in the law currently, or at least some of us think that this way, of putting something into the public domain. You have a right. It exists until it expires, which currently would be, you know, life of the author plus 70 years. So how do I, you know, this is the absence of that right. How do I get that right away from me? Some of us that like to think about these things would say, well, you can't. Public domain just exists when the rights expire. So you have to, you know, for people who are trying to rely on a work that is out there in the universe, and if they're trying to do something with it to commercialize it, build upon it and transform it into something that they can then commercialize, they may not be comfortable with just assuming something is in the public domain, or an author saying, it's in the public domain, I'm never going to exercise any rights. Because we're not entirely sure that authors can do that. They can license, and they can license and say, I will never enforce any of my rights against you. But you know, as we've seen, some authors may feel that way, but their ancestors, their future you know, grandchildren, nieces, nephews, may say, you know what? Grandma was crazy when she wrote that transcript, and she was all about the art, and she might not have wanted to capitalize on its value, but we understand. We're more hip, we're smarter, we're more savvy, whatever, or we just really need money. And they might say, you know what, that it's subject to copyright protection, the rights haven't expired, the rights have transferred down to the next generation, and even though grandma didn't want to exercise her rights against you, we do, because we've come to own and inherit those rights. So the idea of something being created today and being put into the public domain makes some of us, the lawyers, a little antsy, and so we have this concept of a copy-free license that is almost there. It almost gets you into that public domain, and maybe something that down the road you'll be able to rely on if you go and create and adapt and modify something that someone else has created. Open source is what I traditionally think as a copyleft license specific for software. Like I said, people use it interchangeably, but mostly it's been developed with the idea of freely or more freely transferring rights or licensing rights in software, subject to some very specific requirements. That if you do put source code, or if you do put a software program out into the world, you have to make the source code available. You cannot impose additional restrictions on what your adaptation is that's more restrictive than what was given to you under the original open source license, and some other requirements. So I'm telling you this now. I'm giving you this definition just so that you realize that there may be some finer differences between copyleft and open source, especially if you're dealing with a creative work that is not software based, so that you can make a little bit more evaluation. As we get into the next segment of this, I'm going to start using them interchangeably. So I get it. Use what's comfortable. Understand that maybe if you're using an open license for a non-software work, you probably want to be careful about the licenses that you're selecting for that, just because some of them just don't make sense. And I think this is my last definition, I think. Creative Commons. This is another attempt, another system for putting work into a public domain-like status. It is a system of 6 different types of licenses that one can use for putting creative work, again, non-software related products into the public's use, subject to some limited restrictions. There's 6 different licenses, the different types of licenses. Some of them are fairly restrictive. The Attribution license, that lets you maybe take my slides, but you have to take all of my slides. You have to have my name on them, and you can do nothing else with them. But if it's a photograph, let's say, or a piece of music, that may be fine. That may be a good use to allow others to have. You can, but they go all the way down to much more open sorts of systems where you have the ability to take something like my slides, give me some attribution, but you can create, you can make changes to it, you can adapt it, you can modify it. You can even do that for commercial use. It doesn't have to just be for another educational series. You could use this as part of some type of commercial use. And, that's available to you as well. And then there's, shades of difference in between. Some of the licenses only allow for non-commercial use. Some require that, okay, well, I've given you this license to use and modify, so anything that you create with it, you also have to put into the public under the same sort of license. Share alike is how they use it here. But it's, it's a system that allows for the sharing and the development of, additional creative work. And these things, the open source, the Creative Commons, these are all rooted in the idea that copyrights go forever now. And if Disney has its way, it will continue for even longer, so that we all protect the virtue of Mickey Mouse. So if we're looking as a society to build, a more robust public domain or put more creative work into a state or a system that allows the expansion of ideas, the collaboration, and that's what these systems are for. And they're good. And I like them now, so despite my article from a long time ago. So I threw a lot of vocabulary at you and I said shades of difference. So I've tried to just kind of represent it graphically for you and to rest your brains a little, because those slides are kind of dense. This is just kind of the scale, the sliding scale of the rights, the copyright rights that exist upon creation. You have the most favorable to the author on the left, least favorable to the right, and where everything kind of falls in between. Open source, you will hear open source being used with copy-free types of licenses as well as copyleft licenses. Creative Commons comes all the way through to something that's a little bit more restrictive than most copyleft in open source licenses. So that's where everything falls. And that's important for you to think about as you try to put your own work out to the public, and may want to retain some control or may not. And you need to evaluate that. So hopefully that slide's a little useful for you. So I want to talk for a minute before we get into the legal licensing of any of these works under any of these systems. There are pros and cons to using a proprietary system, traditional license, versus an open source system. So I took a little bit of time to try to break it down a little bit for you. At the end of the day, I did try to make this very neutrally, a very neutral view. Some copyright people hate open source, others, and they'll tell you open source, very bad, negative stuff. And then all the open source enthusiasts will say proprietary, very bad, negative stuff. This is my attempt to just kind of create present a neutral view. License fees, if that's something you're trying to commercialize your creative work, you can get that under both systems. More likely for an open source system, those license fees are going to be really low. But you're able to charge for users to have access to your code, your work, if you want. If you offer something under a proprietary system, you can capture probably more licensing revenue out of that. Access to source code, obviously proprietary. No, we never ever let anybody see what we've coded or what we've developed. No one gets to look under the hood, and it's mandated under an open system license. Control of features, and this one I think with a lot of my clients when they're trying to decide how much of their technology, of their thing they want to put out into the world, control is actually a big issue for them. The creator, if you keep your work proprietary, makes all of those decisions. If you put something into an open system, the other developers, the people who get to use it and adapt it, are really going to drive how it moves forward in the future. So that can mean that, and it often is the case with a lot of open source software, at least, that the user interfaces on a lot of open source software are not particularly user friendly. They're not really splashy stuff. Microsoft and Apple do a much better job of making their pages pop and making their applications very user friendly. Developers that are using an open source based code, they might be really keyed in on a particular feature, probably not necessarily how it looks to the user or how the user has to go through 3 steps to get to the feature or to make it work rather than just click of a button. Those things get decided by the masses, not necessarily by the creator. But if you are trying to contribute to a larger, broader conversation about a technology, you might welcome that. You might like to see where others take the idea and watch it transition and transform. Security, this one I'm on the fence about. The perception is that proprietary software would be more secure, but I don't know that has been proven as of late. But in an open system, it's very possible that bad users could come in and incorporate some sort of malware into some source code. So there is that perception out there. Like I said, I don't know these days how that really holds. Development cost, proprietary, you're developing it all yourself. You're never going to let anyone see your source code. So everything, the creation, the features, the modifications in the future, bug fixes, all the rest of it, it's all driven by the owner. And that takes time because they don't have unlimited resources and they don't have unlimited manpower. In the open system, development costs are usually much lower because if you can get the interest of a community that is going to help build that product out for you and those features out for you. So it's generally, it can be a shorter time frame and less money to do that. Quality of the work product, I hear originally it was the open source, you don't know who's really touching your stuff, and so maybe it may be susceptible to more bugs. Others say, well, no, because now you have thousands of people working on and perfecting a technology, and that should address bugs fixes so much more quickly. At the end of the day, what people who have really studied this have said that it's about the same. Proprietary software is likely to have just as many bugs or just as many issues as open source. One isn't really better quality than the other. I only have that one slide. Huh. So if you're thinking about putting your creative content into any sort of open system, some things to keep in mind. Open source licenses are appropriate if you are okay with giving up the control and you want that public collaboration. That's especially true for hardware and software. To give up that control, you are compelled to actually give up the source code, your underlying code for your products. The whole idea behind open source is that we're building more innovation, we're supporting innovation, we are putting more into a public domain-like state. So there will be the requirement that if you take something that is from an open source environment and use it, you will then need to honor that license and carry it through to whatever you create. That being said, there is the ability to have mixed source software and mixed source, I guess, anything. You just have to be careful about how you weave those two things together. If you bring a piece of open source into your proprietary software, it's going to have to be segregated. You're going to have to honor the license, but you can architect it so that you can put your proprietary information out into the world under a proprietary license, and they can live together. If you are looking to commercialize a business, and I do work with companies mostly that are looking to take something and make money with it, and you're looking to get investment dollars, venture capital to help build your business and bring it to scale, this issue of open source and how much open source and where it lives versus where your proprietary stuff lives is very important to them because they're investing in you and they're investing in your product, and they want to know that you own your product. And if you don't, they want to know what you don't own, because that's a very big deal to them. So if you are considering using open source in that way to commercialize something that you're developing, you really want to have a conversation with an IP attorney who will walk you through this a little bit more specifically to your arrangement, so that you're setting things up from the start in a way that will keep you from having to spend lots of money separating all of this in the future. So. Oh, there's the rest of it. Oh well. Creative Commons, this is for work, I would say non-software type of work, and I kind of went over through the definition, what the licenses are, and why you might want to use this system. I did include just a depiction that I found on the internet. We'll call it fair use. I think it is fair use, by the way. To just show you what the different types of licenses are, and the relative pros and cons and whatnot. It's a good system if you are putting something out into the world that is not software based, and you want to give people the ability to create more from that. I really do like this system. I will tell you though that you got to look at the fine print on this. If you go to the site, thecreativecommons.org, and see and read more about this, it all looks very warm and fuzzy, and they'll have those great little icons for you to tell you which licenses are available, but you actually have to click on the license and actually read it. It's not as simple as the little pictures suggest. But like I said, I think I've probably gone through this. Oh, a couple of points to think about with Creative Commons. If you are going to use that type of system for licensing your work, these things generally don't come with any warranties, and that's good for you as the author. You're not representing that something is original, useful for a particular type of purpose, and all the rest of it. So, some good news there. But if you are using a Creative Common work, understand that you're not getting any sort of representations at all, or any sort of warranties at all as to what the quality is, or what the usefulness of what you're using is. If you are employed, like most of us in the world, that you might be under some restrictions, guidelines. If you're in the university, you're probably in a better place than the private sector. But if you have an employment agreement that talks about the works that you make and who owns them, you might not be able to put something into a Creative Commons system. You might need to have a conversation with somebody. I think here at the university, if you created something and you wanted to put it into under a Creative Commons license, I think you could have a very pleasant conversation with the people here about that. But if you're employed elsewhere, just keep that in mind, that you may have some legal obligations that require you to not give the stuff away for free and under these sorts of licensing arrangements. And I think that was it. Yeah, I mean, we've covered that. So I'm just going to wrap up very quickly then on just implementing the licenses themselves. Once you've decided, do I want control? Do I want to be able to commercialize it? Do I want to be able to control the future adaptations? Do I just want attribution? Do I want to put it out there, make sure that whoever uses it also honors what I have done in terms of granting license rights? You go through all of that, and you land in a different place depending on your goals, your end goals for your product and for yourself. So having done that exercise, you will then decide if it's proprietary, which you're going to go see, an attorney about so that they write the right license for you. If it's open source or copyleft or copy free or under a common Creative Commons license. Once you've made that decision, the licensing part of it can be fairly simple. The general public license is what's commonly referred to for open source and copyleft types of licensing arrangements. This is the list of the most popular ones. They've already been written. There's nothing to write. You have to, you're using an open source system, you got to use an open source license, and the good news is that they've already been written. If you are acquiring something under one of these licenses, you better read the license. They do vary, and they will spell out for you what your obligations are to honor the license through redistribution and modification. So there are probably lots more. If you go to, is it Free Software Foundation, this is what the most popular, most common open source licenses are. There are a lot more. There are organizations out there that certify open source licenses, so you probably want to, if you're going to use something that's under an open source license, you want to make sure that it's been vetted and it actually provides the rights that you think it does. Just because it says it's an open source license, verify that, see if it's been certified as an open source license so that you can use it and understand what the restrictions and the permissions are. But generally, this is the nuts and bolts of the license. It's giving you a perpetual, worldwide, non-exclusive, no charge, royalty-free, irrevocable license to reproduce, prepare derivative works of, display, publicly perform, sublicense, and distribute the work and derivative works. Yay, that gives you everything. You can go do everything, right? So that's the easy part. But then I'll tell you about how you need to move the ball forward in terms of licensing anything that you create, this redistribution concept. And this is where it gets a lot more detailed. With the idea that you're not taking something that someone else has freely given and then pulling it back in and making it proprietary and capitalizing on this. So, I'm saying this like, oh, this is where the scary stuff is, but keep in mind this is, for the proliferation of, collaborative works and a more robust public domain type system. So, respect it, but understand that you have to follow this. If you take something in the open source and you try to then make it proprietary, people are going to show up angry with pitchforks and torches and want to have a conversation with you about it. And they will try to actually make everything that you've built off of that open source also subject to the open source license. Copy free, well, there are lots of copy free licenses as well. As you can see, I do love the one with the asterisks, but also can be also certified. So there are other accrediting associations that have these lists and will tell you, yes, this license, such as it is, qualifies as a copy-free license. So use those. And if you want to use, put something out into the universe under a copy-free license, you can take, this verbiage, and I will show you it. It can be as simple as that. That is the entire license, copy-free license, under the GNU all-permissive license. So. And then for Creative Commons works, as I said, I'll just point you to the website. There are 6 different licenses. Click on the link that says legal code to get to the actual license. Creative Commons, you like to think, oh, well, it's open source. Of course, everything's going to look like this. Everything doesn't look like that. All those other licenses that I've mentioned, pages long, some of them. And that's true of the Creative Commons licenses. They're fairly comprehensive. The idea is that they're trying to give you the clearest rights. They're trying to give you universal rights, rights that will be respected and can be put into other languages. All great things. It just takes a lot of words for them to do all of that. So just read them. Go to the law school. Have one of the law school kids in the IP clinic help you with it. Just read them. And with that, I promised Tim I'd leave about 15 minutes for questions, and since I cannot stay for the afternoon session, so let's open it up. Or you can go have lunch.
You hear a lot of conversation about this. This is somewhat new to me. Do people really understand the details that are involved? When they just talk about common, licenses and fine, it's great, and we just go do it. And this is extremely complicated.
Yeah, I agree. I don't think it's as I don't think the system, the idea of it is great. I like the idea of it, truly. But we are trying to get around a right that exists upon creation, and that takes nuance. And people have approached it in different ways. And I think everyone thinks, oh, open source. And even, when I saw the topic, I was just like, open source, so simple. And then I started really thinking about it. I was like, well, there's Copyleft. And then I came across copy free. And then I'm like, but public domain, what about that? And it's not as simple in all hearts and flowers and rainbows as I think it's commonly believed to be.
That was an impression after your very good explanation. Who polices this? In other words, who finds out if somebody's violating a license?
The Free Software Foundation is probably the biggest police agent. So there are some nonprofits that are very committed to these movements and will verify people's use if they're able to do so, and bring lawsuits if they believe companies like Microsoft and Sun and the big players have embedded open source and done so in violation of the licenses. So it is not the government doesn't come knocking on your door, but there are agencies that will come, nonprofits that will come knocking on your door.
I was curious if there was like a deposit requirement. I appreciate that if you're going to then offer your version of a widget or the original source code that's been perfected or something, that you need to offer that to people under the same license. But do you actually have to deposit it at all? And if so, like, are there places, like, can you go to the new license for maybe one of the Red Hat things or something? Can you find them all in one place, or are you still kind of doing a similar problem with copyright itself, where do you even find this stuff? Who has it?
The underlying source code, you have to make the underlying source code available, and in the license itself, it will tell you where you can go to find it.
Oh, okay.
So there is a depository that the owner, or the creator, makes for its thing, and people can put back into that, or if not, then they'll tell you where the next, where their version lives.
As you know, Creative Commons, the foundation, they do very big work to have a translated and adapted version of the license for every single country that is member of the movement. But in open source, that still hasn't happened yet. Do you think that is necessary or not? Because I come from Costa Rica, and we don't have software patents, which are in the GPL 318, and we don't have copyright, we have author's rights. So I always question myself, do we need to translate GPL to Spanish and adapt it to Costa Rican law to be able to use it correctly?
That's a really good question. I've never looked at it. My gut says yes. You would need to, if you create a work in Costa Rica, it is subject to the copyright laws. They will be similar, most likely. So you can maybe be able to adapt a U.S. GPL, but I wouldn't say, like anything else, I wouldn't say just yank it off the internet and start using it. Probably not. It's probably not the advice I should be putting out into the world, so I will not.
Just to comment to that, I'm an attorney in Estonia, and I also deal a lot with these copyleft issues. And in practice, what we do is basically we apply those same US licenses to Estonian contracts. Whatever the warranty means, whatever the limitation of liability means in US law, it has a different but kind of similar concept also in Estonian law. So we just try to interpret them according to Estonian law, but mostly because Estonian market is so small, these licenses will apply, worldwide to all the other markets. So in the end, you still have to, wherever you have a dispute or issue at question, you still have to look into that country's jurisdiction and try to make the license suitable to that jurisdiction. But in the end, I think that there are analogs in all the countries. Some countries more, in some countries less. In Estonia less, but then we have to take guidance from the US law and the Free Software Foundation dispute and precedent experience as well.
Right.
Give a lot of guidance. Which brings me to my question. So one of the most popular issues I come across with is that there's a lot of startups who are building services based on software as a service solution. And of course, they want to save their cost and they want to use some open software, which is available there. But they embed that open source software in their software as a service solution, which is firewalled and not made public to the users. So basically, the user comes online, logs in, starts using the service, but he never gets access to the underlying software. And if that underlying software which is what this open source code, which is embedded into the software as a service solution and licensed maybe by GPL, and GPL says that even if, so my question is, it basically says that even if this open source software which is licensed under GPL is embedded into a software as a service behind your firewall, that is still a publication and you still need to make that underlying software public. Is that the right interpretation or not? I haven't really figured out the answer yet.
Yeah. I'd say, which side do you, I can argue it both ways, and I've seen it argued both ways, right? I mean, that's always the risk of using an open source code and trying to embed it or marry it with proprietary is where does the open source license end and where do your rights to your proprietary code begin? And I don't know that we've really I don't know that the body of law is really matured on that yet. I believe that they can be married and that some of it can be open and some of it can be proprietary as long as it is properly segregated, and that you can put that license out. But if you do, you've got to make the open source part subject to redistribution. In my mind, you do. But you can still keep your proprietary stuff under a proprietary license. So I say you got to be careful about it. And I don't know that we've got a well-developed body of law yet. Certainly the Free Software Foundation is going to tell you if you embed any sort of open source into a proprietary product, that the entire product, the entire source code could be subject to the open source license. I don't think anyone's going to go that far just quite yet. Certainly if you're abusing, then, and that's the thing about case law. It's always made up from the cases of the really bad act. And so we then try to come up with generalities, but I don't know. Yeah.
Just a question, it may not be the right place, maybe it's one of the later sessions, but is there any sort of encouragement or guidelines from UNH for researchers, to which path they should take here, or is it really in every case, like if you're going to make a lot of money out of that, if it's a great research or idea, the university encourages a controlled license versus just open source? Anybody know?
I don't think, do you?
The policy will speak to it, and it'll be pretty fact specific. I think it'll depend on, but I do think your point earlier that they're incredibly easy to talk with.
Right.
They're gonna chat with you about your.
It's almost up to the individual researchers.
Well, in collaboration with, and it could depend too, like if you were funded by the federal government,
Right.
that may dictate, they may not be free to say go for it, because the government may be having some rights there too. But yeah, I think the policy will speak to it primarily, but then I think the conversation about particular facts, because I think their interest too is not holding back innovation, but
it's
the
kind of a
institution of
balance.
education,
Yeah.
but also just if there's commercialization possible, you may want the vehicle of the university behind you or not, or whatever, but I think that,
I have another comment regarding the licensing of open source and proprietary. I think we found in open source it sort of was under some limited
licenses that didn't have a lot of contributors. It tended to be Wimdelt where the primary author was, there was a sort of a separate, we would take up the project software and have a discussion with the primary author and say, okay, are you happy with us doing it this way? So even though it was kind of open source, the primary author in the end would say, okay, yeah, that's fine. And we were sort of comfortable with that. I don't know whether that fits with any legal framework, but it was kind of a way to work the combination of open source and proprietary. I don't know whether that is reasonable or not. It seemed to be sensible.
Yeah,
Sometimes do the open source for each proprietary. The proprietary aspect might be maintenance, right? It might be customer service and things like that, where you could give the client the source code anytime you want. It's of no use to them, pretty much, you know. But your ability to license them, your skill set, and your ability to pick up the phone and help them. Like, so I think there's other ways to marry it that may not just be the code base.
right. I agree, and I think the open source movement is very much rooted in collaboration. So those sorts of outreach efforts to the original author and getting input, in some development spaces works beautifully. If you have lots of people contributing work, additions, modifications to an original work all over the world, it's hard to have those conversations. So it really kind of depends on the underlying work itself and the community that's working with the original work. Okay, everyone ready for lunch? Thank you.
Thank you.